The record in the matter of the state of Michigan versus Leroy Blevins, 25-00122 and 25-00581 FY, council appearances.
George, on behalf of the people, Your Honor.
And good morning, Your Honor. Stephen Mills, Mr. Blevins is present and staying to my right.
Okay, I have two files for Mr. Blevins here. One is for possession of meth, the other is arson in the first degree. My understanding is there's going to be an unconditional waiver, is that correct?
The arson is gonna be an unconditional waiver. In regards to the possession, only one officer appeared today, Your Honor. Other people unable to proceed at this time with possession file. But I did inform defense counsel that if we may reissue this, depending on what happens in circuit court.
The people are unable to proceed and are making a motion to dismiss.
The defense will be making a motion for this. Your Honor.
Why are we making the defense make a motion when you're not able to proceed? I don't know why they do
Either
that.
way, we'd like the dismissal.
I don't know why they do that. Either you can proceed or you don't.
Means I get to win a motion though. That's always fun.
That is true. It does get your win numbers up. Motion granted. And it puts the onus on us to print the paperwork too. And so there is an unconditional waiver on the arson. Is there an offer?
No offer. Negotiations continue, Your Honor.
And that is a good statement.
Mr. Blevins, you understand your right to have a preliminary examination in this file. You understand your right to require that the prosecution establish that they have sufficient probable cause that the crime being charged was committed and sufficient probable cause to charge you as the person who committed the crime. And you wish to unconditionally waive your examination. Anyone threatening you to do that? Any promises being made to you to waive your exam? Bind over date is going to be March 26th. That's the date the circuit court gets the file from the district court. You do not need to appear in the circuit court on that day, okay? Court date will be a pre-trial in circuit court. Even your attorney will be made aware of that date. I have that you're receiving your mail at 430 North Larch. That's still accurate?
Yes. Well, it might have to be changed. They said that they were wrong to do that.
They didn't tell us that.
Okay, so I can check that in.
They told us the actual opposite, that they will receive the mail.
If there's any change around, we'll make sure that pretrial services is updated. Has the most up-to-date information.
Sounds good. They've not been returning any of the court mail, that's for sure.
Okay.
Okay, let's see here. Phone number ending in 5654. Is still your number?
894-9654.
9654.
Okay, you're on,
Thank you.
No problem. Okay, bond in this matter was set at 25,000, 10%. That will continue. Any additional matters for the record?
No, Your Honor.
Nothing to defense. Thank you, Your Honor.
You're all set. Harvey Edwards is in custody. He could be brought up. On the record in the matter, the state of Michigan versus Henry Percy, 25-00605. Here's for the record.
George, on behalf of the people.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of, I'm going to say Mr. Hersey, but it uses she her pronouns, and I would, I just make the court aware that Mr. Hersey is to my right.
Thank you. Today was the date that was scheduled for a preliminary examination. I also ordered the bond to be revoked because I was made aware of several bond violations. First, the bond violation alleges that there was a pretrial release order that was signed on the 25th of February, which is the date that you were arraigned. You were told that you need to report to pretrial services within 48 hours of your release from custody. And the information that I have as of March 10th was that you had failed to do that. There's also an allegation that you violated the condition in the pretrial release order, section D, that says that you are not to commit any crime while released. I have here that you were arraigned on the 7th in file number 25-0482 FY at the 53rd District Court for failure to return rented property 20,000 or more, and that you bonded out of Livingston County on 8th. So you would have the right to have a contested hearing on violations if we proceed with these violations. Why did you not report to pretrial services within 48 hours of your release?
I thought that we had to do that after the preliminary hearing. I guess I was,
When did they say report to pretrial services 48 hours after your preliminary hearing?
I don't know, maybe I got it wrong. I'm sorry. I did not report on purpose. I thought that was the calculation. Like after I got the preliminary, because I thought the preliminary hearing is where they decide if it's gonna be a charge or anything, right? That's what I was
You've already been
thinking.
charged.
Okay.
You were arraigned.
Okay.
That means charges are pending. The
Okay.
preliminary hearing is where we establish if there's probable cause to continue the matter to trial. That's nothing to do with any of your pretrial release orders. Anything that is told to you that you need to do at arraignment begins immediately.
I know that.
And so one of those things is that you have to be in contact with pretrial services because you are charged with a felony. My understanding is that you did check in with pretrial services. When was that?
I talked to Nicole. I called yesterday when the attorney let me know that that's what I needed to do because that was the violation. And Nicole called me back this morning, the lady from pretrial services, and I did my registration with her.
And then the new matter, which is in Livingston County, the date of the incident was, I think, after this matter, counsel?
It is alleged to have been after this matter. It is still pending. It's set for a probable, I believe it's probable cause conference. I want to say next week.
Yeah, the Tuesday.
So it has not been disposed yet. There's just the charges.
And,
No, don't.
Administrator as your character reference on the case, running to that court is really diabolical. How are we proceeding in the underlying matter?
Your Honor, this was a reset from because she was in custody at the PCC, and we requested, and the court, I believe, granted the idea of having this set as a probable cause conference here today. There were no witnesses.
I did say treat this as a PCC because I believe that, yes, that's right. That makes sense now. No, it's all coming full circle in my brain. Got it. Why she came down here to tell us that. Got it. Okay.
So at this time, we would ask that you put reset for a preliminary exam at this time. Now that she's out of custody.
What's your home address?
1800 Teal Ave. And they put my no contact order, but we wasn't sure if he was gonna move. He was moving out the day that of the incident.
Just don't,
I'm sorry.
yeah, that's all right.
So I was
You're
giving
right.
her.
Just
1800 Teal Ave is your home address. What address are you staying at?
That's what I'm saying now. I was
1800 Teal?
Yeah, I was because he had the no contact. I was going to the Massachusetts Ave. What I gave you guys, but
Don't,
I just stop you so I can check the magistrate no more order and make sure you didn't violate it by going there without permission. Because it says that you will be staying at 1707 Massachusetts in Lansing, but now you're staying back at the address.
yeah.
Okay, and the other party is not there, correct? Okay, but your phone number is still 730-48. Okay. As to the bond violation for failing to report to pretrial services, I'll dismiss that violation. I'll revoke or quash the bond, the bench warrant, that is. This looks like you did get out on the 8th. It's technically, you should have reported to pretrial services within 48 hours of your release, so that would have been Tuesday. Would have been the date you need to report, so you're technically 1 day off. But you have been in contact with your attorney, and so that she can advocate and save you from having to sit in jail for a violation. And then as to the other violation of the picking up a alleged pending action, I wouldn't be able to do anything with that until you figure out what was going with the other action anyways, and that's not meaningful. So I'll hold that in advance. Let's see what's going on. We're gonna continue to an exam on this.
yes, Your Honor.
Okay. April 24th at 9 AM. The court's gonna find good cause to go beyond the 21 days. So for your information, you did have the right to have your preliminary examination within 21 days of the date that you were arraigned, which is back on the 25th. That's why it was scheduled for today for a preliminary examination, but because you were in Livingston County and we could not get you here for the probable cause conference, that pushed us back in timeline. And so I have to go beyond the 21-day timeline to reset this, okay? You understand what just happened there?
Yeah,
I can explain it again.
I think I got it.
Okay, just make sure, you don't have to think you got it. Be sure that you have it before you leave.
I got it.
Okay, and so typically if there's a timeline issue, you would either waive the 21 days freely. Maybe there was an issue and your attorney didn't get discovery request, or you got a doctor's appointment or something to that effect. You could waive the 21 days for me to reset it. Otherwise, I have to find good cause to reset it. I can't just reset it beyond the 21 days. Is what we're doing. And so I'm finding good cause because you were in another county that required us to written you here. Livingston County doesn't let us put you on Polycom for your PCC. So that's what's going on here. So we'll do April 24th. You'll appear in person. There won't be any further violations of the bond between now and then. You'll report to pretrial services regularly as you're supposed to. You'll not be within 2,000 feet of wherever the alleged victim is. So that's where he works, lives, or goes to school. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm or any other dangerous weapon. And you're not to travel outside the state unless you first get permission from the court, okay? Do you have any questions about your bond? Okay, any additional matters for the record, counsel?
No, Your Honor.
No, Your Honor.
Awesome, we'll get you a notice here.
Okay, I'm gonna update our system with that.
We didn't got, bring the person up from jail yet. no? Okay, Mr. Palmer is here
I am.
with Jacob Garcia.
Yes, ma'am. He's here as well.
Very good. 24-06239, council appearance.
George, and on behalf of the people, Your Honor.
Thank you. Good morning, Your Honor. Robert Palmer of Public Defender's Office on behalf of Jacob Garcia, the gentleman who's standing to my right.
Oh, this was a domestic violence third that's set for exam today. Are we ready to proceed?
No, Your Honor, the people unable to proceed at this time, the necessary witnesses to appear.
Thank you, Your Honor. The defense moves to dismiss for lack of probable cause.
Motion to dismiss is granted. The people do have the right to reissue this charge against you if the witness does appear and is ready to proceed. Do you understand that?
Yes, ma'am.
Do you have any questions?
No, ma'am.
Let's see, you're not untethered, okay. Still need to give us 72 hours to get any no contact orders or anything out of the system, okay?
Yes, ma'am.
Okay, we'll get your copy of dismissal in just a moment. Thank you. State of Michigan versus Ahmad Rashad Taylor, 24-03295.
George, and on behalf of the people.
Lieutenant from the Public Defender's Office here to represent Mr. Taylor, who is standing to my right.
That was scheduled for preliminary examination. I have a CCW clean including fourth and felony firearm count.
Your Honor, the defense would like to request, well, that Mr. Taylor be able to waive his 21 days and we reschedule this matter. I was asked to.
21 days. This was, that was waived in
Okay.
24.
All right, well, then I will be asking for adjournment of this matter. I was asked by my office to take over this case a couple days ago. I noted when we were going through the videos, we noticed that the one officer who was kind of a key officer seemed to be missing. I contacted Mr. Anid. His office sent that over at the end of yesterday, but my office still hasn't had a chance to like download it from the MSP system. So that's why we were asking for an adjournment so we can go over that.
Okay, no problem, because yeah, it looks like Trooper was on vacation November 15th. I found good cause to adjourn.
Okay.
So I'll just reset this, okay?
April 24th at 9:30.
April 24th, 9:30. Do you have any questions for the court today, Mr. Taylor?
No.
Okay, we'll get you your notice to appear. The bond will continue throughout this time. Any additional matters for the record?
No, Your Honor.
No, Your Honor. You.
Thank you. Yes, sir. Have a seat so we can get you your next court date, okay? This is Mr. Edwards. Okay, State of Michigan versus Harvey Jesse Edwards, 25-00552. Council appearance.
George, and on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Edwards. Your Honor, if we could pass this briefly, we're working on a plea sheet here for Mr. Edwards.
Mr. Mills,
Um,
can you get that? Be careful now, because you're not gonna get workers' comp in here.
That's workman's comp, I believe.
That was a frolic.
Yeah, right.
No, can you give it to Mr. Taylor for me? Thank you.
Yes.
Just, wait. Was that the notice?
Yeah.
I think the top one. Thank you.
So it's my first time.
No problem. Okay. We're not ready on that one. So I don't see Miss Donnelly.
I gotta finish.
Someone filling in for Miss Donnelly? Okay, she's just step out. Oh, I don't see her on there. Schroeder is here on Liddell Jackson.
Yes, Your Honor.
You're not ready on that one yet either?
I'm ready on Mr. Jackson. We are not ready yet on Mr. Edwards because there's a plea sheet we're working on.
Okay, what about Gino Garcia?
I am not.
Yes,
on-
here.
Okay, on the record in the matter of the people of the state of Michigan versus Gino Garcia. You're right next to a mic and you're using your full voice, Ms. Schroeder, so I need you to whisper because you're right next to that mic. Thank you. This is 24-00948, council appearance.
George, and on behalf of the people, Your Honor.
And Attorney Luke Goodrich from the Public Defender's Office here to represent Mr. Garcia, who's standing to my right.
Okay, Mr. Garcia was scheduled for sentencing today. See, I did not have a pre-sentence report because it says he did not appear for a pre-sentence interview.
Your Honor, in speaking with Mr. Garcia, I'm kind of confused as to what exactly happened. He claimed that he had got on Zoom to do the meeting. It didn't get through. He claimed that he spoke with them on the phone after the fact, was waiting to hear back from them. He also stated that he went to Pat's to get an assessment, and Pat said, well, we have to have the probation, the paperwork from probation beforehand. At the end of the day,
What?
nothing got hit.
Is this a joke?
Got that. So that's what I'm,
He logged into Zoom for a meeting on the 31st and no one appeared.
No one appeared. My thing buffered for almost an hour.
Your thing buffered for almost an hour, so that means you had a technical issue.
Yeah, I guess.
Now you guess, you had a technical issue. Did you come in person?
No, I called. I called down.
And you spoke to who?
My probation officer actually picked up. I called probation because I didn't know.
Who's
who
your
it was.
probation officer that you spoke to?
I never got his name, but when I called, he picked up and said I was supposed to be with him. And then, hey, we couldn't go forward no process because he didn't have no paperwork from the floor or whatever.
From the 5th floor. He is on the 5th floor.
Yeah. I'm
Yeah,
not sure.
you had some orders that was given to you. I spoke to you.
I mean,
Well,
called
wait a minute
probation.
now, you're trying to talk this over. You were here before me. I set this for sentencing. I gave you an order. I told you that you needed to report to pretrial services within 48 hours. If Dale can wait just a moment. If you can give me just a moment, because he's getting remanded into custody. I gave you orders to report to pretrial services or report to probation within 48 hours. And that you were to complete a substance abuse assessment in preparation for sentencing. We are setting sentences out 2 to 3 months. And in those last 2 to 3 months, I have nothing from you.
I did everything you asked.
Oh, well, you didn't, because I don't have a substance abuse
They
assessment.
wouldn't let me take it.
Oh, okay. Well, guess what? We'll get it taken care of for you.
No
They'll be
problem.
remanded so we can get it done.
Yeah, see.
Everybody else comes in here with their assessment, don't have any problem. Did your other clients have these problems?
Call
Look,
probation.
I'm not talking to you. Did your other clients have these problems where they can't go get an assessment at Pat's?
I can't, I don't recall that being an issue.
Because it's not.
I even got letters from Pat stating to tell y'all that I came, so.
Unless
I
there's
even
some
called
confusion
probation
about him
officer.
already being on probation versus.
They were
being
saying something about
in
the paperwork
anticipation.
and the flip floor, never made it to.
The probation, the Pat's doesn't need to work with the before to do an assessment with you.
Probation officer.
You need to get an assessment and then you sign a release so that it goes
Yeah, they
to
can't
our
text me.
5th floor, but you didn't even get an assessment.
I did, I went to the flip floor and did everything you told me.
No, the
I left
assessment was not from the 5th floor. It was
The
that
assessment, the test.
you had to go get a substance
Yeah,
abuse
they wanted to give
assessment.
me assessment abuse without the paperwork from probation.
What
probation
paperwork?
officer. I don't know, they said they didn't know what to test me on to give me a test.
Well, if you had showed up and appeared at the time of
I
your,
did. Zoom didn't work. And I even
oh,
called, you know, the
Zoom
whole
didn't
stuff.
work and you didn't appear in person. And you also think that it's appropriate to go back and forth with me too. When you didn't take care of what you were supposed to do since January. I'll reset this for April 24th at 9 a.m. By then, hopefully, we'll have a substance abuse assessment and a completed pre-sentence interview. They'll meet with you while you're in the custody of the Ingham County Jail. Okay,
Your Honor,
yes.
Ms. Jennifer McCarty has 2 matters that are scheduled. I don't believe the prosecutor is able to proceed on either one of those.
Is that accurate, counsel?
Yes, Judge. Sorry.
Okay, thank you. 24-03158 and 24-03173, appearance, please.
George, and on behalf of people,
And Luke Goodrich from the Public Defender's Office here to represent Ms. McCarty on each of these files, Your Honor.
Okay, there was a larceny from a person, and then there was 2 counts of assault with a deadly weapon. No witnesses are here?
correct, Your Honor.
Okay, counsel.
Your Honor, at this time, the defense would move to have both of these matters dismissed, and I am waiving Ms. McCarty's appearance for this particular hearing.
Okay, the motions in both files are granted as to dismissal without prejudice, and you can advise her of what that means. We'll get you a copy of the dismissals in just a moment.
Thank you, Your Honor. I will take those downstairs to Ms. McCarty. So,
Thank you. Running McGinnis, correct?
Yes, Your Honor. I would just ask for 5 or 10 minutes, see what witnesses I have.
Yeah, I'm just asking just to know, but I think we're gonna do
Harvey,
Harvey Edwards, and did I have another certificate? Alan, oh, but she's in custody, I don't see Miss Donnelly. Let's see. Miss Schroeder's still working on paperwork. I saw Miss Robinson, but I don't see her anymore.
got a plea on Roman Smith, if you want to do that.
Okay, that's 24-03483, council appearance.
Representative on behalf of the people, Your Honor.
Morning, Your Honor. Robert Hinojosa here on behalf of Mr. Smith, who joins me today.
May I approach?
Yes.
Oh, I need to go grab a witness for
Take
this.
your time. You're back on the record in the matter against Roman Smith. My understanding is there's a plea. Is that correct?
Correct, Your Honor.
The offers for, you can stand. The offers for the defendant to plead guilty to the use of meth under MCL 333.744042A-A and indecent exposure, MCL 750.335A. I can't read the last portion.
My handwriting is terrible, Your Honor. And those are the pack codes that you just listed.
No, I don't know what this says here.
Can I approach?
Yes.
Oh, 1 year and 1,000.
Oh, okay. 1 year, 1,000. 1 year, $1,000. Okay, is the maximum penalty on that one. And the first count, 1 year, $2,000 is what I believe that says.
Yes.
And you want to accept that offer today, sir?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, I do, you can put your hand down. I have an advice of rights of the information sheet. Where's the second page? There's one last right on there that you need to know. Okay, so you read the rights that are listed here. You understand all the rights here. Do you have any questions about those rights? And you're willing to give each of these rights up? So that means you're gonna give up your right to be presumed innocent until the people can prove you guilty. You understand that? So you have the right to require that they prove your guilt by proving each element of the charges that are being brought against you beyond a reasonable doubt. You have the right to remain silent at any trial and not have silence be used against you. You have the right to see, hear, or question any of the witnesses that are called to testify against you. You can subpoena witnesses that will testify on your behalf. And you also can waive your silence and testify at your own trial. You understand that? And you want the right me to get you to give these rights up? Any promises being extended to you if you give up these rights? Are you currently on probation or on parole? You understand that by pleading guilty to these amended charges, it could result in convictions that you may need to report to your current employer, or you may need to put these convictions on future job applications. These convictions could also have impact on immigration status you may be seeking, or where you can travel outside of the United States. So you might want to go to Canada or vacation someplace else, and you could be denied if you plead guilty to these. Do you understand that? Okay. As to the amended count 1 of use of methamphetamine, how do you plead? And as to the amended count 2 of indecent exposure, how do you plead? Factual basis, please.
Thank you, Your Honor. I want to take you back to November 23rd, 2014. You remember that day where you incurred your part? And that's in the city of Lansing, county of Bingham, state of Michigan, right? And on that date and time, were you in possession of methamphetamine? And was that for your personal use? And you used methamphetamine on that day? What else did you do on that day? Might be indecent exposure. What do you mean indecent exposure? Did you expose yourself? And was it reasonable for a person around you or near you to see you? And by exposing your person, I meant your genitalia or your private areas?
People are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea and I find it to be made freely, voluntarily, and intelligently. This matter is set for sentencing, May 2nd, 9 o'clock in the morning. Prior to your sentencing, you need to have a pre-sentence report prepared. When you leave here today, you got to go down to the 5th floor. You're going to check in with our probation department. They are going to get you set up and scheduled and provide you further information about your next meeting with them, which is for them to do an interview for this pre-sentence report. I'm also ordering that you provide a substance use assessment. And so you can get a list of approved assessors from the probation department, or you can ask them to do one for you at your expense, okay? But I need that done and I need to report to them, and you need to make sure you meet with them. If your Zoom doesn't work, you come in person or you make contact. It's your responsibility, not theirs, okay? And that all of these things will be done in preparation for the report, so that when we come here on May 2nd, I don't get a no report letter from them saying that you didn't comply with the order that I'm giving you right now, okay? Do you have any questions about what you need to do between now and then? Any additional matters for the record? Counsel? Oh, thank
You
you.
said May 2nd, 9 a.m.
May 2nd, 9 a.m. You can have a seat and we'll get someone to come get the file so that you can meet with, go down to probation. Thank you.
I got both. Yes, I got both. Thank you.
I'm confused. This is a 48-hour hold. So why does it say that on there? Referring to pay.
Oh, that was just- Oh,
So what?
Okay.
Oh, not, that doesn't apply to show causes.
Okay. Oh, there's a whole bunch of stuff. Yeah.
Yeah,
Yeah.
the collection
Yeah.
thing.
All right. Let me take a picture.
Yes, you can go
It looks good.
Okay.
Okay,
Then I will sign that.
Oh, you have.
let's see.
I got them.
Yeah.
I got that.
This one, right?
Thank you very much.
Sorry.
It's okay. Listen, I get it.
We got that quickly. Okay, we just did Smith. You said we're ready on your matter, Ms. Schroeder.
Yes, Mr. Jackson is ready and I may be ready on Mr. Edwards here in just a second as
What are
well.
we waiting on with Edwards?
Pardon me?
What are we waiting on for Edwards?
Just signatures. Now, we got all the paperwork done. I just need to see if you have any questions.
Okay, I'll let you finish that so that we can get them back.
Do you have any? Okay, and you can write up here. I got my pen. I can help you with that, okay? Once we get through.
I'm sorry?
Can you sign from here? Okay.
He can come back. He can come over there. That was only because someone was standing there when he got upstairs.
Yeah, we were just trying to figure out how to help him, make sure he could sign you guys. You got it okay? All right, I get it. No, yeah, good luck on that.
You still have a Houston file?
I'm sorry.
You still have a Houston file?
Very good. Yeah, yeah, I got you. I get it, I can appreciate the situation.
Ready?
On Mr. Edwards, yes, we are ready, Your Honor.
On the record in the matter of the people of the state of Michigan versus Harvey Edwards III, 25-00552, counsel appearance.
George, and then I'm having people.
And yeah, if you can bring him over here, that'd be probably better. And Assistant Public Defender Aaron Schroeder on behalf of Mr. Edwards, who is walking over and you see standing to my right. Your Honor, this is going to be a plea. I have the advice of right form as well as the plea sheet completed. May I approach?
Yes, thank you.
Thank you.
You're just gonna stand right there, sir. Okay, so I have here a plea offer. It says the people are offering for you, Mr. Edwards, to plead guilty to added count 6 and 7, which is attempted police officer assault with resisting obstructing. And that's under MCL 750.81 D1A. Each count, maximum penalty 1 year and or $1,000 in fines. And upon successful plea, the people will dismiss counts 1 through 5 and the habitual offender notification. Do you understand that plea?
Yes.
Okay, you want to accept it? Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury. I need you to say it.
Oh, yes.
Thank you. You can put your hand down. Okay. You understand your rights in this matter, sir? Okay, so I do have an advice of rights and plea information sheet. There's some weird things going on over there. Let's see. Make sure we get to forms this time. We did. Okay. This is your signature, sir?
Yes.
Okay, and these are the rights that you would have to give up today. That includes your right to be presumed innocent. So as you're standing there, you're considered innocent until proven guilty. So you have the right to maintain your innocence and require the prosecutor prove your guilt by proving first each element of the charge being brought against you beyond a reasonable doubt. You understand that? I'm sorry?
Yes.
You want to give that right up to the presumption of innocence? You want to give that right up?
Yes.
Okay, and so that comes up with giving your right up for trial up, and so that means you'll give your right to proceed to jury trial, your right to cross-examine or question any other witnesses that the prosecutor intends to call against you, your right to call witnesses for yourself to testify at your trial, or to waive your silence and testify at your own trial. You understand that? Anyone threatening you to get you to give up these rights? Who's threatening you?
Oh, no, nobody. I'm sorry. Some wind was blowing in my hair when
The door opened, so it probably, yep, I get it. Okay, any promises being extended to you if you give up these rights?
I mean, I
Who
understand.
promised something to you?
No,
Other than the plea agreement that we put on the record. I'm sorry, Your Honor.
Any promises being made to you to make you want to give up these rights? Did someone promise you anything to get you to plead guilty? Okay, okay, all right. Are you currently on probation or parole?
No.
Okay, you understand that by pleading guilty, you could have to report this to an employer or a future employer. You understand that?
yes.
You also could end up with a conviction that has impact on where you can travel or get immigration status. You understand that?
Yes.
And are you pleading guilty because you believe you're guilty? That one gets them, so that always stumps the people. Do you believe you're guilty? That's why you're pleading guilty? You sure? As to the amended count 6, or the added count 6 and 7 of police officer assaulting, resisting, and obstructing, how do you plead? Factual basis, please.
Thank you, Your Honor. Mr. Edwards, back on February 18th of 2025, were you at or near a location of near the intersection of East Saginaw and Washington Avenue? Over there by the park. Can't remember the name of the park now, of course. Oh, goodness. Durant Park. Were you in your Durant Park?
Yeah,
Okay, and you, at some point, you walked through that park, correct?
yeah.
Okay, and that park, to your knowledge, is located in the city of Lansing, county of Hingham, state of Michigan?
Mhm.
Yeah, is that a yes?
Yes.
And at that time, there were a couple officers that were wanting to have you stop. Would that be correct?
Yes.
Okay, so that would be Officer Weller. If I were to say that there was Officer Weller and Officer Vanderwerf, do you have any reason to think that that was incorrect? Those are the names of the officers. Okay. And you knew that they were officers, correct?
Yes.
They were wearing uniforms, they had a police car. And
Yes.
actually pulled up on you. And they indicated they wanted to speak to you, correct?
Is that a yes?
And ended up where you did not stop them, and in fact, you ended up starting to argue with them, correct? All right, at some point, you took a swing at one of them, is that correct? Or I think actually both of them. Yes?
Is that a yes?
Yeah, Your Honor, if the court or the prosecutor have any further questions, thank you.
Right, and just for the record, this was amended to attempted.
It was, Your Honor.
Okay.
You were satisfied, Your Honor. Just one quick thing. I think you might have said in regards to the PAC code for attempt RNO, it's 750.81D1 and parens A.
I
That's
said
what,
that.
okay, I just wanted to make sure. I
Yep.
don't know if I heard. correct.
Yeah, and the court is correct. I thought that there was necessary information that needed to be included.
No, I just said that because I remember, I stated it at the beginning of the plea, what the offer was, but then when I said when I asked him how he pleaded, I did not say attempted.
I
So
understand.
that's why I was clarifying.
And yeah, thank you for the clarification, Your Honor. Thank you.
Thank you. Okay, no further factual basis, counsel.
Correct.
Okay, the court is satisfied with the factual basis. I'll accept your pleas. I find your pleas to be made freely, voluntarily, and intelligently. This matter is set for sentencing May 2nd at 9 o'clock in the morning. My understanding is that the magistrate required or requested, I should say, that he have a CMH eval prior to release. Did that take place? I don't have a report.
It has not, Your Honor, and from the best I've been able to figure out, I did email the court earlier this week, asking if that was listed as a bond order or bond condition, because
He put it right on an order for CMH eval prior to release to be determined if he can be released safely.
my understanding is that Katz didn't have it as a court order, and so they have not put him on the list. That was from reaching out to them, and that's my understanding is that maybe why the delay has happened, is that he's now sitting on a wait
It's
list.
on the pre-trial release order. CMH evaluation ordered prior to release to determine if he could release safely. There's no other order that could go out. It's there. I don't know why they don't have it as an order. It's in her order.
Your Honor, would it be possible for me to get a copy of that email to me, the bond?
The bond form?
Yes, so that I can send that forward to, and ask CMH what is the issue here? Because that was one of the things I was lacking in my file. To be able to point to. But I will note, he has a guardianship, Your Honor. I don't know if the guardian even knows he's in custody. It's a public guardianship, so they have an office.
Okay.
And I would note that because of his current custody status in jail, he has not been able to actually, even if we were to kite for cats, my understanding is they would not come see him anyway because of his custody status. So I'd ask the court to consider allowing him to be released at this time. has been in custody for as long as he has been here.
200 extra. Here's another file. Yeah, yes, 200, sure. There's a 200 cash shorty in this misdemeanor file. He's not being released unless he's evaluated for the order.
Okay. I will follow up again on that and see where we can get one. Thank you. Oh, it's because of the cats. Gotcha. Oh, how much longer is that? I would hope. Okay. It's difficult when we're supposed to be on treatment. Pardon me? Oh, no. We gotta get you back on track with your treatment. Because this is probably not that. Okay, feeling better. Appreciate it. Okay. Gotcha. Sorry. Thank you.
We're still on the record, so everything you're saying is just being recorded, that's all. I'm putting a note in here so that he's not released until it's done. So I have to revoke his bond until I have to, because the jail has been releasing people that shouldn't be released. And they've not been getting information to CMH, obviously. So I am revoking the bond pending the evaluation. And once the evaluation comes back, if it comes back that he's can be released safely, I'll do a PR bond versus a 2010% bond, which is what it's currently set at. But I need the evaluation done first. Any additional matters for the record?
No,
No,
You're all set.
Bye.
Let me out. Yeah, I'm gonna let my officers go.
Give me a moment, Yolanda. Something out here.
I was just trying to get out.
Are we running an exam on Jackson or Jones?
No, on Jackson, it's gonna be a waiver to circuit.
Jones is also a waiver.
Okay. Yeah, you can bring up McGinnis.
Oh.
I'm sorry?
McGinnis is right there.
They're co-defendant, so you can't run without one without the other. For the record, in the matter of the people of the state of Michigan versus Liddell Jackson, 25-00589, council appearance.
George, in on behalf of the people.
And Assistant Public Defender Aaron Schroeder on behalf of Mr. Jackson, who is present and will remain momentarily standing to my right.
Okay, Mr. Jackson was scheduled for a preliminary examination for carrying concealed weapon, police officer, assault, resistant struck, and felony firearm. How are we proceeding today?
Your Honor, it's gonna be unconditional waiver to circuit court as charged on the complaint. The offer to waive is to plead the CCW, dismiss the remainder, and the forfeiture of the firearm.
That is correct, Your Honor, and I noted a moment ago that this matter is going to be doing the waiver of the preliminary examination. Oh, yes, thank you, Your Honor. My apologies.
No problem.
Multitask here. Form we talked about balance. And more. Okay. To sign. Thank you. Right down.
Yeah, may I approach?
Yes, thank you. All right, Mr. Jackson, you understand the purpose of the preliminary examination? So you have the right to require the prosecution put forth evidence to establish that they have sufficient probable cause that the felonies that you've been charged with were actually committed, and then sufficient probable cause to charge you as the person who committed those felonies. You understand that? And you want to waive your exam? You understand the waiver is unconditional, so you can't say that it's based on any promise or any condition. It's gotta be freely and voluntarily waived. You understand that?
Yes.
Okay. Anyone threatening you to get you to waive your exam?
No.
The threat, promises being made to you?
No.
Your bind over date is gonna be March 26th. That's the date the circuit court gets the file from the district court, okay? You do not need to appear in the circuit court on the 26th. Your next court date will be set after they receive the file. It'll be for a pretrial, and you'll be notified of that. Your attorney will be made aware of that next court date. Do you have any questions at this time?
That bind over date again?
March 26th. The bond was set at 3,010%. It's like a notation that the defendant travels out of state for employment purposes. That will continue. Any additional matter for the record?
No, Judge.
No, Your Honor.
Okay, you're all set. Thank you.
Let my trooper go real quick.
Okay, thank you.
And then I will be in touch once I find out who.
Yeah, that's what I was trying to do.
Yes.
On the record in the matter of the people of the state of Michigan versus DeQuinderick Jones, 23-03270. Appearance, please.
Yours is on behalf of the people?
Aaron Robinson, Assistant Public Defender for Mr. Jones.
Okay, Mr. Jones was scheduled for preliminary examination, and my understanding is this is also a unconditional waiver, is that correct?
It is, Your Honor. May I approach?
Oh, yes, thank you.
Thank you.
Okay, Mr. Jones, you understand your right to have a preliminary examination? You understand your right to require the prosecutor establish first that they have sufficient probable cause that the felonies you're being charged with were committed? And then they need then to establish sufficient probable cause that you committed the felonies. You understand that? You want to waive your right to an exam? Anyone threatening you to do that? Oh, yes, I don't understand why this was so old. This was when the officers were here for silver girls. Was there an offer at all?
Negotiations continue, Your Honor.
Your bind over date is March 26th at a time to be determined by the circuit court. But that's not a date that you need to appear to the circuit court. Do you understand that? That's the date they'll get the file from the district court. Your next court date will be a pre-trial. Your attorney will be made aware of that. Do you have any questions for the court today? It's a bond set at 2,500 cash surety, and that will continue. Any additional matters?
No, Your Honor.
No, Your Honor, thank you.
You're all set.
All right, I'm gonna ask for a 10-minute break. I gotta gather and see what minutes I have and I don't have for these two court files that are running.
Sounds good.
Back in about 5 or 10 minutes.
George.
Yeah.
Jury room and conference room too.
Okay.
We're running McGinnis. Is that correct?
Yes.
Okay.
Yes, Your Honor.
They can get set up.
Which one do you have? Wait. Carter?
Yes.
Do you prefer to sit there or do you wanna?
Yeah, I think this is probably easier.
Okay. Almost like.
Yes. Yeah, I'll call you back in half an hour. Sure, just so you know, if we were to run both of these, I'm adding home invasion second. Yeah, true. Oh, the other thing, for one of the file, I don't remember. The Baker Street, I'm gonna submit, I don't have a printout at the, different checks, guys. I'm gonna show this to the. See what she provided us. The second. I don't know. You have it. Yeah. Still. I just showed, I usually get it something like that, as long as. This. Yeah, this is, she maybe should put the chance. See. Well. Yes, because after it was 20. Yeah. For the rear road, I have 1, 2, 3. Matt, Kara, both officer, one, Wayne, the homeowner, Baker Street, here. Any questions, Mr. Carter? No. Scarlett, which one you want to do first?
Your cases.
I'll give you the pleasure. I think, Baker Street would be a little bit quicker. Want to do that first?
It doesn't matter which one goes quicker out here for the whole thing, unless you're gonna release me.
You want to take lunch? Nash? Abby?
Yeah.
If you can ask, let Judge know, preference would be the 00233, 00232 files. That doesn't matter, but preferably that one goes to first.
Oh, to do those first.
Yeah, same time. Or first.
What file?
The Baker Street file.
Okay.
Yep. Two. Yeah, the first one's- And then the next one, I think that's the end. It's a- That's your vote.
All rise. Please be seated. On the record, excuse me, in the matter of the people of the state of Michigan versus Alan Ray McGinnis, 25-0233 and 25-00621, and then Dwayne Henry McGinnis, 25-00232 and 25-00623. Council appearances.
George, and then on behalf of the people, Your Honor.
And thank you, Your Honor. And good morning, Jared Austin appearing on behalf of Mr. Dwayne McGinnis. He is present with me at council table.
May it please the court, David B. Carter Jr. on behalf of Alan McGinnis, who is present.
Oh, today was the date scheduled for preliminary examination on both files, both co-defendant files, and my understanding that we are running those files today, correct?
Both, Your Honor. The people asked if we can start with the 233, 232 files.
Whichever one you prefer to start with. That's fine with me. Any preliminary matters before you call witnesses?
Your Honor, sequestration of witnesses, I will police that, and so will defense counsel. My only witness, my late witness is Ms. Dorr, which is in the courtroom today, and she's the first person I'm calling.
Any other matters?
I would just join in the request for sequestration.
Nothing for us.
Sequestration is granted. You can call your witness.
And the people called for Tita Dorr. That's right.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes.
You can have a seat. Okay, there's a microphone that's in front of you, and the purpose of that microphone is so that the lady behind you can take down everything that's being stated on the record, but that microphone will not amplify your voice in the courtroom. So I need you to speak as loud and clear as possible, okay? Also, if there is a question that calls for a yes or no answer, you must say yes or no, because we can't understand ums and ahas on the record, nor can we articulate head nods, head shakes, okay?
Yes.
If you don't understand the question, you can always ask us to repeat the question or rephrase the question. If there's an objection, you will stop speaking. I need to make a ruling on that objection, and then I will tell you if you can give that answer or not, okay?
Yes.
State your first and last name and spell both.
My first name is Brigitta. Last name is Dorr. Birgitta. Last name Doerr.
Thank you. You can proceed, counsel.
Thank you, Your Honor. One quick thing I forgot to mention. I apologize. I informed council, I believe yesterday and maybe this morning, that if these exams were to run, that would be adding a home invasion, second, if the facts present on this file.
Very good.
And I apologize for pronouncing your name wrong. Ms. Dorr, what relationship do you have to 6119 Baker Street?
I am the property manager.
Okay, explain what that means.
I have been retained by the owner of the property to manage the property to lease out the property as a rental.
Is that a business you own?
It is a business I own.
Okay, we'll take it back to June 27th, 2024. You remember that day?
Yes,
What do you remember from that day?
I was on my way to work and I got a telephone call from the police department saying that
Object to hearsay.
Back on the listener.
Objection overruled.
the police called me and asked me if the 619 Baker was occupied.
What did you tell them?
I told them, no, it should not be occupied.
What information did you learn from that phone call?
That I had two people that were in the property that were stating that they had permission to be in the property and they were taking plumbing and wiring out of the house.
Did you ever give any permission for that?
No,
You verify that nobody ever had permission to enter that home?
no, the house was vacant and boarded up.
All the windows are boarded up?
Correct.
So if you want to enter the home, how would you enter the home?
And through the door.
Okay. When did you, after that phone call, when did you go to that home?
After the police told me that I could go and I needed to secure the property.
That was the same day you got the
Same
call?
day, correct.
Did you notice any, did you notice something? Let me ask this, were any of the boarded windows taken down?
The basement window.
Okay, so it was boarded up?
The basement window was not bricked up.
It was a glass window
There
though?
was a glass.
And it was how did it appear when you arrived?
It was broken.
Did you end up entering that home?
We did.
What did you notice, that caught your attention?
That they had been ripping out the wires and the plumbing and we had holes in the drywall.
A lot of damage?
Yeah,
Did you make phone calls to arrange fixing of that damage?
we had to call contractors then.
Okay. Do you remember getting invoices?
I did.
If I was to show you the invoice, do you remember those invoices totaling more than $20,000?
They were
Okay, and that was for the damages done?
correct.
And do you understand, the two individuals, they never had permission from you or anybody else to enter or do anything that you noticed that they did?
When the police contacted me and told me that they had bought them in the house and they asked me what I wanted to do, I said, I want to prosecute them because they're trespassing in the house. I did not have any permission for anybody to be in the house.
Is that why you're here today?
That is why I'm here today.
If I was to show you a copy of the receipts, would you recognize them?
Yes,
Aaron, I provided this. Yeah, may I approach? Yeah, let the record reflect, I am showing the witness victim on my laptop, which is the receipt that I will ask her about.
that is correct.
That amount that you got receipts of, that was over $20,000?
That is correct.
Okay.
Are you referring, excuse me, are you referring to the two receipts
Yes.
in there? I would ask that the prosecutor gets an opportunity to forward those receipts as an exhibit to us once it's in.
I will. It is, they, council already has that, but I will provide it for them. Did it look like they were trying to steal items out of there?
Not items.
Objection, calls for speculation.
Well, you're on it.
Looks like it's a joint objection, correct? You
Yes.
stood up. I didn't hear you.
Yes.
Okay.
I can ask if she's circumstantially believed as a layperson, whether it looks like they were trying to steal items out of her home. Or out of the home.
Mr. Carter?
Well, this is my issue with this, the question. First, he's used the word they, which there's no evidence here that she even observed what was there. We have a time frame that she went there. Now, she could possibly say the house looked like somebody was
Things have
trying
been
to
taken
steal
from it.
stuff.
I could agree. I think the
And
way
I
the,
think
I was just gonna say, I think the way the question was formed could
I
be
think
formed better.
it's speculative as to the.
I agree. I think you need to rephrase the question, so I must sustain the objection.
Master, how long after the phone call from police did you arrive on scene?
Maybe 2 hours.
2 hours later? When you arrived, was any law enforcement there?
No.
Everybody was gone?
Correct.
And you entered the home?
Correct.
What did it appear, how did the home appear to you when you entered?
It was evident that they were removing the plumbing.
I have to object again on speculation. She used the word they.
Well, he didn't ask the question that way. She said they, that could be anybody. They've not identified your clients at this time, so they or someone be interchangeable at times, so objections overruled.
As you were saying.
That they were taking the plumbing and electrical out of the house. It was a 2-story house. So they had been moving both floors.
Tell me how you know that.
Well, the electrical panel feeds the wires up, and we had B&D Electric meet us on site and American Plumbing meet us on site and go through with us what has been taken.
Do you notice anything on the outside of the house?
About broken window. So we had to secure the property, so we had to go through everything to make sure it was secure according to the police. So the only thing that I noticed was the broken basement.
You said broken basement window?
Yes, ma'am.
Based on the appearance and the boarding of the houses, were there, besides the front door and that basement window, would there possibly be any other way somebody could have entered?
There's a front door and the back door, but neither of those were broken.
But there was entry or broken glass in that basement window?
Correct.
No further questions at this time, Your Honor.
Cross-exam,
Sorry, Your Honor.
cross-examination.
Okay, thank you. So this day that you were talking about when you went to the property, you were responding to a call from law enforcement. Is that correct?
That is correct.
Prior to that occasion, when was the last time that you had personally visited that property?
We're required to do that once a week.
And so do you recall approximately how many days prior to when would have been your last visit? You know, if it was a matter of a few days, 1 week?
I don't know.
Okay. And when you do these weekly visits, do you just observe the outside or do you go on the inside?
We have to do both.
And so the last time that you would have been there prior to this incident, when law enforcement called you, you would have gone on the inside as well?
That is correct.
And is that something you do yourself, or is there other people involved?
It is me, and we do have meetings.
Is it just something you do a visual walkthrough of, or do you document it in any way, take notes, pictures, anything like that?
We walk through and we have to look at the front, the back, the sides, because of the continuous break-ins that Nancy is experiencing.
And is there any kind of security systems or alarm systems on the property?
No,
Okay. Any type of cameras?
no,
And on this day in that law enforcement called you there, you did not personally observe anyone taking or removing any property from the house, is that correct?
that is correct.
Thank you, that's all the questions I had.
Thank you, Mr. Carter.
Thank you. It's Ms. Dorr, correct?
Yes,
Ms. Dorr, my name is David Carter. I represent Alan McGinnis in this matter. I'm going to ask you a series of questions. If there's a question you don't understand, please let me know and I'll try to rephrase that. Fair enough?
correct.
You said correct. Fair enough. You
Yes.
understand
I
that.
correct.
Okay. Ma'am, I'm just following up with what co-counsel talked about your last time you went on the property. You were kind of vague on that. You just said that we're required. Did you actually go in to this property and take a look at it prior to this incident? Okay, you said you're required, but I want to make sure that you actually did. So you did.
Not always I do it, but it's a weekly in our contract. It's a weekly, whether it's me, my father, or our maintenance staff.
Okay, and do you have log books
Yes.
that say this?
Correct.
And would your visiting this property have been recorded in a log?
Yes,
Will you provide that over to the prosecutor upon request?
yes,
All right, so you indicated that you do a visual inside and out because of the multiple break-ins in the Lansing area, correct?
correct.
And did you do that in this incident?
I came out after the police called me and told me that they caught these people in the unit.
Okay, in the last time prior to this unit, you said that it had to been within a week, right? That you had gone in there or somebody. It's
So
a, ma'am, that's another thing. You gotta wait until I'm totally finished before you answer. You may be anticipating and you may be right, but I have to finish, okay?
Sorry.
So this happened. Do you know what day, what day this occurred on? In other words, a Monday, Tuesday, Friday, one of.
I don't recall what day.
Okay, you don't recall which day. Do you know what days you normally go out to this property?
I do,
And what days are those?
Monday.
Mondays. And is that because of where it's located? You probably have a list of houses that are in the same area, so you visit them that way? Or is that your scheduled look at date for all your properties?
That is our, Mondays and Tuesdays are our scheduled look at dates for all our classes.
All right, and just so that I'm clear, you did go out there on the regular scheduled day for this property, is that correct?
That is correct.
All right. And when you went there, you said that you take a visual. Do you take pictures or anything?
No, we don't.
All right. And if you had recognized something, would you have logged that into a book? If you had saw some damage inside the property, would you have logged that somehow?
It just depends on what the damage would be.
Okay. Well, some of the alleged damage in this house is torn out wire. Would you have documented that?
I would have called the contractor.
you have any records that indicated what this house looked like prior to you becoming the property manager?
I did.
Okay, and so you know whether or not there was damage inside that house before you became a property manager, is that correct?
That is correct.
Because this house was boarded up, right?
We had a tenant that had moved out, and so there was a month that it was vacant.
Okay, so this house was only vacant for a month? Is that correct?
I believe so.
And were you the managing person on this house when that individual was renting also?
That is,
All right, and when that person left, did you document what the house looked like inside and out?
that is correct.
When you say that is correct, I'm assuming those are yeses, right?
Yes.
We just want to make sure. for the record.
Yes. We're right.
All right, and did you take pictures of the house when these people moved out?
I don't recall.
Do you know if there was any type of court action on these prior tenants for damage inside the house?
No, there were not.
Okay. And can you please describe to me what the damage looked like on the day you received the police call and you went out to the house?
There was missing pipes. There was holes in the drywall. And I immediately called the contractors so that we could get it documented. And they could go through it with me,
And,
because I have not had that experience before.
okay, so you don't have the experience to determine visually whether or not this type of damage by a single person or two person would take 15 minutes, a day, 2 days, 3 days?
That is, yes,
Was the house pretty much damaged throughout?
Yeah.
And do you know how much piping or plumbing was taken out of the walls in this house?
I don't, that's why I got the contractor to fix that.
Okay, and unfortunately, we don't have a hard copy of that, or does co-counsel have a hard copy of that? So. I see that one of the proposals by American Plumbing was $14,537.93. Is that your recollection, ma'am?
If that's what the bid says.
Oh, and there seems to be a bid on this for a natural gas water heater. Is that correct?
I don't know.
You don't know, so you don't know.
have it, I don't.
Oh, okay, well, you're the property manager of the house.
Correct.
Was there a natural gas water heater missing?
If that's what the bid says.
Okay, well, when you were there at the house and you're walk through, right after the police called you, did you see a natural gas water heater missing?
Aaron, that asked and answered already.
I don't think I did. I think she avoided it, so I narrowed it down to make it better for
It's a
her.
new question, so he did say, did she see one missing? So she has to answer that one.
Did you see one missing?
No, no.
Okay. Did you see any pressure balancing valves missing?
Yeah, I would ask if she knows what that even means, because I don't.
Okay, do you know what pressure balancing valves are?
No,
Moen one handle single function shower faucet in Chrome, did you see that missing?
Do you know what those
Okay.
are, ma'am?
I do.
Okay.
Did you see? Let me try to ask this a little bit of a different way. It seems like there's a lot of damage here or missing things. Did you see any of these items actually on the property but disconnected in any way?
I don't understand.
And that's fair, and thank you for doing that. For instance, there's copper pipe plumbing missing, correct?
Correct.
And did you see the actual copper plumbing on site? No. And apparently there was a gas heater missing. Did you see that disconnected on site?
I was not downstairs.
Okay. Did you see, what items did you actually see on site that was not connected to the house anymore?
Specific, be more specific.
That's as specific as I can get.
So I saw attachments that were missing to connect, like the faucet to the wall, and then there's pipes that run up, like supply lines and pipes that run, like the pipes were missing that go to the fixture.
Okay, and you saw that they were missing in their place that they were supposed to be.
Supposed to be.
Okay, did you see those on site just laying around
No,
in the basement?
no.
Okay, so apparently whoever did this had to have taken this stuff off the property at some point.
Speculation, she should answer that.
Objection.
Oh,
Did you want to respond to the objection?
I don't think it's speculation. Either the items were there or they weren't.
Repeat your question.
Okay, so these items that, like the water heater and the piping that you saw missing, that you didn't see a pile there, somebody had taken them off site then, correct?
I don't know.
You don't know.
For the record, the objection is overruled.
Do you know what, and I might have asked this question, and I apologize if I did. Do you know what day June 27th of 2024 fell on?
I do not.
You'd have no dispute that that was on a Thursday, correct? Well, I shouldn't say correct. You don't dispute that June 27th of 2024 was on a Thursday.
If that's true.
Judge, I'd ask you to take judicial notice that June 27th, 2024 was on a Thursday.
So noted.
So we know that on this incident, at least where you were called on site, was on a Thursday. And at best, the last time you were on the property was on the 25th, correct? At best, because that's a Tuesday.
But that's the Tuesday. It was Monday or Tuesday.
Okay, and you would have logs showing that and who actually went into the house, is that correct?
That is correct.
Now, this house is boarded up except for, you indicated that the doors, correct?
Correct.
Are those, do those have a, just a normal house lock to those, or are they padlocked? Do you know how that house is secure?
They have the deadbolt.
Thank you. I don't think I have any further questions. Mr. Austin?
Can you redirect?
Is it fair to say that you're living with us right now?
Yeah.
Yeah. And this incident happened like 9 months ago.
Correct.
And you have two defendants sitting from both sides of you with two defense attorneys.
Right.
All right. So maybe some of the answers or the way you answer some of the questions is based on the nervousness.
Yes.
All right, no further questions.
Can you give me the address of the location again?
619 Baker Street, Lansing.
Let this witness be excused.
Yes, Your Honor.
This is a frustration order, ma'am, so you're not to discuss any portion of your testimony with any other witness, okay?
Yes, ma'am.
You're free to go.
Thank you.
Yeah, people call Officer Matt Carlson.
Matthew Carlson.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do, yeah.
Thank you. Be seated. You can proceed, counsel.
Officer, were you working on June 27, 2024?
I was,
What are your shift hours?
6 a.m. to 4 p.m.
Shortly after you started, did you get a 911 dispatch
Yes.
to where?
I don't know the exact address on Baker Street, but it was a vacant house on Baker Street.
City of Lansing, County of Bingham, State of Michigan?
Yes.
Were you in full police uniform and vehicle?
Yes.
What was the reason for dispatch?
A witness had called and said that either two males going to this vacant house that needed to be vacant.
What did you do when you got that information?
We arrived on scene, checked the security of the house. I believe there was a door unsecure or a window unsecure at some point throughout the house. We made several announcements at the front of the house. And then.
Were you given information, were you given permission to enter the house? You or another officer?
I don't recall exactly if we were given permission, but we didn't enter before we started making announcements.
At one point, did two people come out the house?
Yes.
Do you see them in the courtroom today?
Yes.
Can you please point to both of them, identify something that they're wearing?
Both of them have Ingham County jail suits on.
Okay, do you know their names?
Yep. Alan McGinnis and Dwayne McGinnis.
Let the record reflect that the identification has been made.
Any objection to identification?
Can you differentiate between Mr. Allen McGinnis and Mr. Dwayne McGinnis?
Alan McGinnis and Dwayne McGinnis.
Without objection.
Any objection, Mr. Carter?
No, you're on.
So noted.
Thank you. I didn't know who was you. Let me ask you this. Did you make contact and did they talk to you? Oh, let me ask you, did you talk to them?
I believe I talked to one of them, but I'm not sure exactly which one it was.
Okay. Would looking at your police report refresh your recollection?
It would.
Aaron, may I approach?
Yes.
Good. Has your memory been refreshed?
Yes.
What do you remember?
I spoke to Alan after we arrested him on warrants, and he stated that he knew the house to be vacant, and that he's been staying there for weeks.
Did he say whether he accused or not?
If
you don't remember, you don't remember.
Yeah, I don't.
So you saw these two individuals in the courtroom today exit the house?
Correct.
619 Baker Street?
Yes.
And you were told by one of them that they didn't have permission to be there and they've been there for a couple weeks?
They said they've been staying there. I don't know if we clarified permission or not.
Do you know how they, do you have any information to make you do you know how they may have entered the home based on your investigation?
Through an unsecured door.
No further questions, Your Honor.
Cross-examination.
Morning, officer.
Morning.
And when you were responding to this call, did you have a description of the suspects in mind, or was it just a call about a couple of suspects?
Two unknown subjects.
Okay. And nothing in terms of like raised articles of clothing or anything like that that you were looking for?
Not that I recall.
And you said you spoke with Mr. Allen McGinnis that day, is that correct?
Yes.
And you did not speak with or get a statement from Mr. Dwayne McGinnis that day? And with your body worn camera captured any of your investigations or all of your interactions that day when responding to this?
It would.
Thank you, Your Honor. It's all the questions I have.
Mr. Carter. Carter.
Is it Officer Carlson?
Yes, sir.
Officer Carlson, my name is David Carter and I represent Mr. Allen McGinnis in this matter. I'm just gonna ask just a few questions. If there's a question you don't understand, please let me know and I'll try to rephrase that. Fair enough?
Yes, sir.
You, did you have contact after you met with the two McGinnis, the two defendants in this matter? Did you have contact with the property manager of this unit?
I did not.
You did not. Did you, so you didn't walk through the property with her at all?
No.
And did you walk through the property at all?
I don't believe so because, or I know that I didn't because we took Alan into custody at the front door and then I was within the patrol car when other assigned officers did.
Okay, so you never entered into the property, so you don't know what it looked like inside. Did you, once you were informed that they were staying there for about 2 weeks, did you do any canvassing around the neighborhood to determine whether that was true or not?
Me personally, no, I didn't.
Did you instruct anybody, hey, this is what this guy says, make sure we talk to neighbors or anything?
I probably talked about it on scene, but I don't know if anybody else did.
What you talked?
I probably talked to other responding officers about it and said what he said, like really his statement to them. But I don't know if anybody else came to this or not.
Who would be the lead guy on this case then?
I believe it was Officer Hatton.
Oh, so it's not you? No. Did you get any direction from the lead officer what to do as any follow-up on this at all?
No.
Thank you. I have nothing further.
You believe your memory might have been faded since this has been about 9 months ago? No further questions. Thank you.
Thank you, officer. There is a sequestration order, so you're not to discuss any portion of your testimony with any other witness.
Thank you.
Thank you. You can call your next witness.
No further witnesses, Your Honor. Nelson.
Argument. Is the defense calling witnesses? I'm sorry.
On behalf of Mr. Dwayne McGinnis, Your Honor, we'll be relying on the evidence presented. Thank you.
We will not be public.
You can make arguments.
And people are gonna be asking that you bind this case or as charged in the complaint to circuit court with an additional count of home invasion second degree under PAC code 750.11083. As all the elements have been met. I'm not sure how the court wishes me to make my argument, but I guess I will respond to any objections. I believe all the elements are met based on the testimony we have. If Your Honor wants to see the receipts that I provided to the witness, I can provide that as well to you.
Was that supposed to be an exhibit?
Yes, it was supposed to be an exhibit.
It was never admitted.
I would agree, Your Honor. It was shown to the witness, but there was never any formal admission made as an exhibit.
I just presume.
As I
think
recall it, there was never a
Agreed.
proposed
It was-
exhibit. It was never moved to be entered.
It was
into
never
evidence.
proposed, nor was it moved to be admitted, and if it was, then it has to be published, and so. But if it was an exhibit, then it should not be published. So I don't know what the intent of that, I don't know what the intent was.
My intent was to give it to you, Your Honor, and either I can publish it now.
Well, you gotta
Or-
make a motion, you didn't get it admitted. And it doesn't sound like they're stipulating to these.
I guess that if it's going to be used to publish to the court to make a decision as to bind over, I think the court is limited to the testimony and any exhibits that were entered during the examination. So I think it would be improper for the court to view something that was never asked to be admitted as an exhibit and was never formally introduced into evidence as an exhibit. So I would object to the publication of a document that was never entered in as evidence during the hearing.
That's fine, Your Honor. Either I can, if I cannot publish it, if you will not allow me to reopen it, I think I still have enough basis to argue the amount that's testifying to based on the witness.
But reopen, you mean recall your witness, is that what you mean?
No, just let me publish the exhibit that she authenticated.
But you never admitted it as an exhibit, you never introduced it as an exhibit, and so that would have given the defense an appropriate time to make an objection to the entry of said exhibits. And maybe their questions would have been different had they believed it was a proposed exhibit. So I can't now admit the exhibit because it was not properly proposed nor moved for admission. And you introduced it under a witness. I understand her testimony. I think she answered questions about, I'm assuming the purpose of the exhibits was, I thought it was to refresh her recollection as to the amount, because she believed it was above 20,000, but wasn't sure. That's what I assumed it was being used for. And so I have her testimony as to the amount.
Okay, I think that's sufficient. Unless you find that to be a legal issue, not a factual issue.
Well, either way, I think that would be sufficient either way.
Okay. Well, Your Honor, as I indicated earlier, people asked if you get by in this case or as charged with the added count of invasion second. I can restate that PAC code if needed. I will address any issues the defense has with any of the testimony or my argument. I have the Michigan jury instructions prepared in the argument, or I think it was plain and simple what we heard today.
You're asking for added count for each for home invasion first degree?
Yes, Your Honor.
I thought it was second.
Sorry, second degree.
Okay, defense argument.
Thank you, Your Honor. I'm going to object to the people's motion for bind over, not only as charged, but for the additional count that they wish to add. I understand the burden at this stage is probable cause, which is a lowest standard we have, at least in the criminal court, but it's still a standard that they must meet nonetheless. They may have enough to justify the illegal entry misdemeanor, which isn't before the court today, because the court only has to make a probable cause determination as it relates to the felonies as they're currently being charged with. And I believe, Your Honor, the evidence that was presented here today is insufficient, even on a probable cause determination, to justify binding the case over to circuit court for further proceedings. At best, they may have established, and I'm not conceding this, but I think best possible light to the people is that they may have established Mr. Dwayne McGinnis was in the house without permission. I certainly do not believe that they have established that Mr. Dwayne McGinnis committed any type of damage or any type of larceny that they would necessarily need to prove as it would relate to the charge that he is currently facing, but also to the request to add the home invasion charge. We don't know, and it was unclear from the testimony of Ms. Dewar as to exactly when she would have been there last to observe the property. It may have been a couple days, may have been 3 days, but during that time window, Your Honor, it is certainly unclear, and neither Ms. Dewar nor any other witness that was presented today would be able to say what the condition of the house was in that interim period. We don't know who, if anyone, may have entered. We don't know who in that interim period may have entered the house, done damage, or taken items. And I don't believe that they have met the necessary threshold for the amount. I think the testimony was unclear as it relates to the malicious destruction of property. I think that was a bit circumspect as to, because again, we don't know when this damage may have occurred. We don't know when these items may have been taken. Certainly, there was no one that identified that they saw Mr. Dwayne McGinnis doing any damage or taking any property. So for those reasons, Your Honor, I think the people's request for bind over must fail on the felony count that Mr. Dwayne McGinnis is currently facing, as well as the request for an added count. Thank you.
Thank you. Mr. Carter?
Thank you, Your Honor. I don't think I can add too much more. What Mr. Austin indicated, I'd be opposed to a bind over on both of those, both of the felony counts. At best, we have our two individuals that were located in a home that perhaps had damage done to it, but we don't know who did the damage. We don't know how they did the damage. And we don't even know when that damage had occurred. So I would be opposed to a bind over on the felony counts. Again, as Mr. Austin indicated, we're not before the court on a misdemeanor charge that obviously would survive.
Any re-argument?
No, Your Honor, I believe circumstantial evidence and to some extent common sense goes a long ways here. Thank you.
Count one is malicious destruction of personal property. Count two being a misdemeanor, we do not need to address, and the people are asking to add added count three of home invasion in the second degree based on testimony evidence. Today's date set for preliminary examination. So with the time for the prosecution to meet their burden of establishing sufficient probable cause that the alleged crimes or alleged felonies were committed and that the parties named in the action were the individuals that committed the alleged felony. So they don't need to prove each element beyond a reasonable doubt. This is just a burden of more than mere suspicion that the allegations alleged were committed by Mr. Allen McGinnis and Mr. Dwayne McGinnis. Count one, the elements required at trial for them to prove beyond a reasonable doubt, but for today's purpose, just a probable cause standard. First, that the defendant broke into a dwelling. It doesn't matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, taking off a screen are all examples of enough force to count as a breaking. Second, that the defendant entered the dwelling. It does not matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, that is enough to count as an entry. And then third, that when the defendant broke and entered the dwelling, he intended to commit, in this particular case, the allegation could be that he intended to commit the count or added count, the count of malicious destruction of property, count one, that is. And that when the defendant entered, was present in or leaving the dwelling, he committed, in this case, again, count one, malicious destruction of personal property, 20,000 or more. And so we had testimony from Miss, I think it was Burgett Dewar. She's the property manager. She indicated that the address in question was at 619 Baker Street. That's in the city of Lansing, Ingham County, state of Michigan. And that on or about June 27th, 2024, the police were called. The police called her and asked if 619 Baker was occupied. She said, no, it shouldn't be, that it was vacant. And the police advised her that there was a report of people in the home or location taking plumbing, wiring, or some other items from the home. She indicated that the house was vacant and that it had been boarded up, that she did report to the address, and that she observed some holes in the drywall, and maybe some other things missing. It doesn't sound like she did an inventory herself, but that she contacted a contractor who came in to do an inventory, and invoices were provided for damages in excess of $20,000. She testified that there was the electric panel was open and wiring was missing, and that there was a broken basement window. She testified on cross-examination that she actually testified, I believe, on her direct, that she visits the property, or it's a requirement that the property is inspected, I should say, twice a week. Then on, I think that was under Mr. Austin's question, actually, that she responded that it was her requirement to, for the contract, to inspect the property 2 times a week. She was vague or unclear as to about what days she would have inspected this particular week, and or if it was her particularly, because she said it doesn't have to be her, it could be her, or I believe her father, or some other entity or agent of hers that could have inspected it. But she did advise, based on cross-examination answers from Mr. Carter's questions, that there is a log that she will keep of the dates that it was inspected, and she typically inspects that property on Monday. I don't recall hearing the other day that she would have inspected it. She said twice a week. It's only 1 day a week. But nonetheless, she said that she would have log damaged, but that's based on what the damages were, and that she would have called to have a contractor to inspect those damages. And that we then had testimony from Officer Matt Carlson, who testified on the date and time in question. He was dispatched to that address, 619 Baker, on the report of a vacant house. A witness advised that 2 men were going through the vacant home that shouldn't be there. And he advised that he made contact, or he saw the 2 individuals that he has identified in the court today as the defendants, Alan McGinnis and Dwayne McGinnis. He stated that he spoke to Alan specifically, and that Alan said that he knew the property had been vacant and that he had been staying there for weeks, or he had been in this property, I should say, for a couple of weeks. And it sounds like there was another officer who did further investigation, but he did not testify today. As to whether or not there's sufficient probable cause, that being more than mere suspicion as to a home invasion 2nd degree, I think based on circumstantial evidence that we have more than mere suspicion. These 2 individuals were seen in the property, which also later had it was discovered there was a broken basement window, and that the defendant, at least one, Mr. Allen, admitted to being in the property and having staying there. However, based on the property manager's knowledge of these people inside of the property, there was later some inventory done that showed some additional damage to the property. And she says that they inspect this property per their contract weekly, Whether or not that's the truth or not, or whether or not that had been done, that's a question for a jury to determine at the time of a jury trial, if it proceeds to trial, as to whether or not done this week, this had been inspected twice that week. It would be interesting to find that out because it doesn't align with the statements allegedly given by Mr. Allen, which is that he was living there or it's been staying there for weeks. And if someone had been staying in a vacant property for weeks and the property manager is inspecting it twice a week, why didn't they know that someone was living there? So one of the two individuals is not being completely honest. And I don't know if that would be Ms. Dewar or if it would be the alleged defendant, Mr. Allen, stating that he had been living there for weeks. There's been no testimony about evidence of anyone living there. I should say that. I think that probably would have come out if there were maybe some information or evidence that someone was living there. I don't know how anyone could be living there without drywall piping or whatever, but I guess it could happen. But the information is that there were large pieces of information or items removed from the property. But also it should be noted that there were witnesses that that was not the witness that testified in court that called 911 and said that there were two people going to a vacant home that shouldn't be there removing things. So the court satisfied as to count one the court is satisfied as to the request to add count 3 of home invasion in the second degree for both defendants. That will be bound over to the circuit court. Count 2, malicious destruction of property based on the same set of information and facts that there was a large amount of electrical wiring or piping that was determined to be missing after locating these two individuals in the home. Circumstantial evidence would lead that it's probably more likely than not that they had something to do with that if the property had been being inspected and there was no reason to believe that there had been a breach of that property prior to the date they were seen leaving the property. So that will be bound over to the circuit court. The bind over date on these files is going to be March 26th. We proceeded on the next files.
One moment. Pardon? Still on the next exam.
I got it.
Yeah. Right, here, people are prepared to proceed. People are first gonna call. Kara Freeman.
Solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury. You can have a seat. Just give me one moment. Someone's logging into my Zoom. Maybe they left. Okay, I state your first and last name and spell both.
First name is Kara, K-A-R-A, last is Freeman, F-R-E-E-M-A-N.
Counsel, you can proceed.
So I'm gonna take you back to February 25th, 2025. You recall that date?
Yes,
Were you working on that date?
yes.
Oh,
Going to the police department.
were you in full police uniform and vehicle?
I was,
How were your shift hours?
6 a.m. to 4 p.m.
Around noon of that day, do you remember being dispatched?
I do.
To where?
It was a house on the corner of Rio and Star.
This,
Rio and
Star.
Does 2107 Rio Road sound familiar?
Yes,
Is that in the city of East Lansing County? Sorry, city of Lansing, County of Bingham, state of Michigan.
yes.
All right, why were you dispatched?
I was dispatched to B&E.
And when you arrived, what did you see?
When I arrived on scene, I was coming northbound on Star. I was approaching Rio Road. When I got to that intersection, I had to wait for the car to go by. While sitting at that stop sign, I observed two white males fitting the description I was given out over the radio.
Are they here in the courtroom today?
Yes,
Can you please point to them, identify something that they're wearing?
sure. One of them sitting to my right in the blue jumpsuit, one sitting to my left in the blue jumpsuit.
Do you know their names by chance?
I do,
Do you know who's who?
yes.
Who's who?
Alan's gonna be to my right and Dwayne's gonna be to my left.
Let the record reflect identification has been made for purposes of preliminary examination, Your Honor.
Any objection?
Without objection.
So noted.
So when you saw them, what happened next?
When I saw them, Dwayne had a very large box. From where I was at, I couldn't tell what type of box it was. Alan was standing just to the right of Dwayne, and he had a blue dolly. And Dwayne was loading the large box onto the dolly.
What did you do when you saw that?
At that point, I believe I called it out over the radio. I hadn't initiated any emergency equipment because I didn't think they saw me at that time. When the vehicle passed through that intersection, I proceeded through the intersection. That's when Dwayne looked at me and then Alan looked at me and then both of them stopped running.
They both ran away.
Yes,
Do you know if they got caught later?
they did.
Did you ever, or what did you do next in regards to your investigation?
Next, I called out the direction that they were running. And then I could observe Alan running northbound through the backyard. I believe it was 4502. Real Road is where I ended up taking Alan into custody.
You remember giving one of these defendants a Miranda rights?
Yes,
Which one?
Alan.
After Miranda, did he talk?
He did not at the time. The only thing that he did state was that he had swallowed or ingested heroin, so I summoned the fire department, paramedic ambulance.
Do you remember Alan saying that the other person was his younger brother? Do you remember anything like that?
Yes.
Did you ever go to the residence and observe any damage, or
No, I did not.
was that officer somebody else?
It was somebody else.
Okay. No further questions, John. Thank you.
Cross-examination.
Good afternoon, officer.
Good afternoon.
So you stated that you were dispatched regarding a breaking and entering, is that correct?
Yes,
And then you saw the two individuals who you later identified as Mr. Allen and Mr. Dwayne McGinnis, and you said that they had matched the descriptions you were given, is that correct?
correct.
Could you go into more detail about that? Do you recall what type of description you were given?
I don't recall, and I don't believe I put in my report the initial description that was given by dispatch.
And so you don't have any recollection as to what description was given to you?
No,
But when you were en route, did you have certain particulars in mind of suspect or suspects you would be looking for?
more so the property that was believed to be taken out of the house. I believe one thing that was mentioned was a microwave. So that was one thing I was looking for.
And you recall if you were particularly looking for a particular race of suspects?
I don't recall.
You recall if there was any particular items of clothing on these suspects that you would have been looking for?
I don't recall.
Do you have a general description of what area they may be going in?
I believe dispatch did say that they were going northbound on Star from Rio.
In your mind, were you looking for someone on foot or in a vehicle, or do you not know or remember?
I believe dispatch said that they were on foot walking northbound. So at that point in time, I believe my response time was 2 minutes. So I, at that time, was looking for somebody on foot because I hadn't been given vehicle that they had left.
Do you know, or did you ever learn the identity of the person who called this in?
I did not speak to them.
Okay. Do you know who it is or was?
No.
Thank you, Your Honor.
No questions.
You were.
Yeah, thank you.
Thank you, Officer Freeman.
Well, next call.
Oh, let me advise you, there is a sequestration order, so you're not to discuss your testimony with me.
Yes, sir.
Well, next call, Adam Walter, I think he's coming in now.
You said Adam.
Walter.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Thank you. You can have a seat.
Thank you.
State your first and last name. Spell both.
Adam Walter, ADAMWALTER.
Proceed, counsel.
Officer, you're dressed in full police Lansing Police Department uniform.
Yes, sir.
Were you wearing that on February 25th, 2025?
Yes, sir.
Do you remember February 25th, 2025?
Yes, I do, sir.
You dispatched at 2107 Rio Road.
I was.
What was the reason for dispatch?
It was for a break and entering process.
And when you arrived, what did you do?
When I arrived, I assisted Officer Freeman, taking one of the subjects in custody behind the house on Star Avenue.
Did you ever find a microwave during your investigation?
I did, yes, sir.
Tell me about that microwave.
It was a fully boxed microwave. It was next to a metal dolly off the road there, just off the Star, just north of Rio.
What did you do with that microwave?
I returned it to the residents. At 07.
This is before noon. Or sometime, it was daylight.
Yes, sir, right around noon. Yep.
Did it appear to be abandoned? Well, let me ask this. The position where you found that, what did it appear to you as and where you found that microwave?
The microwave was on the side of the road in a box. It was by a metal dolly, or on a metal dolly. And it was also by a bag of wires and pipes.
The brand new microwave?
It was in a box.
And what did you do with that microwave?
I put it onto the metal dolly and I took it back to the residents. 2107 Rio.
Was it walking distance?
Yes, sir.
No further questions.
Cross-examine.
I may, Your Honor. Morning, or good afternoon, officer.
Sure.
I think I just have one quick follow-up. You said the house that you went back to was in walking distance from where you arrived. Is that correct?
Yes, sir.
And can you elaborate on that? Are we talking like 30 seconds, couple minutes, or do you recall?
The walk back to the house?
Yes.
It was within sight. It was probably approximately a 30-second walk back to the residence. A minute.
Thank you. That's all the questions I have. None.
Speaks to.
Yes, Your Honor.
Officer Walter.
People, next call, Wayne McGee.
Yep.
So.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. Okay, there's a microphone that's in front of you, and the purpose of that microphone is so that everything that you are saying is being picked up on the recorder so that a transcript can be produced at another time. However, that microphone is not going to amplify your voice in any way. So I need you to speak loud and clear, okay?
Yes, sir.
Okay, all of your responses must be verbals, no head shakes or head nods, no mhm or uhs, because we can't understand that into the record. If there's an objection, you'll stop speaking. I need to make a ruling, excuse me, on that objection, and then I'll tell you if you can give us that answer or not, okay?
I understand.
Okay, state your first and last name and spell both.
Wayne McGee, WAYNE MAGEE.
You can proceed, counsel.
Sir, how would you like me to address you today?
Wayne's fine.
Wayne, what is your relationship to 2107 Ray Road?
I'm the builder for that unit.
Tell me what that means.
I designed it and I was commissioned by the land bank, county land bank to construct that.
Prior to February 25th, 2025, when was the last time you were there?
Probably the day before.
What were some of the things you were doing on that property?
Well, we were in the final stages of the building. We're going around putting together punch lists about minor things that had to be taken care of. And also working out what it was going to cost to repair the damage. We had a lot of missing wiring in the basement already. So we were working on what that was going to cost.
Tell me about that wiring. Prior to this incident, what do you mean?
Well, this particular incident, we'd already been hit twice before.
Okay.
The first one.
Let me ask you this. Sorry, cut you off.
Certainly.
There was already pre-existing damage to the house.
Yes.
Okay. Were there any, after this incident, what did you notice differently from the day before?
Ask me that question again.
Right. I didn't understand it either. The day before, you said you were there.
Yes.
The day after you were informed of another incident, was there anything different?
Two notable exceptions was the microwave that was set in the home to be installed at a later date was now sitting on a trolley in the middle of the living room. We had yet more wiring cut down in the basement. That was two things.
So there was more damage from since the last time you were there.
That was my assumption.
Okay, you're not sure.
No.
Okay. That microwave, was it a brand new microwave?
Yes, it was. It was still in the box.
You know how, were you informed from anybody how it got into the middle of the living room with a trolley or dolly?
I was, and the officer I talked to that was there on the scene when they were arrested together. Said that that's what they found them with out in the sidewalk.
Jack, you're saying unless it's not being offered.
Not being off.
Let's be off for
Back on the listener.
objection overruled.
You end up getting the microwave back.
Yes.
And a free dolly?
Free dollar.
No further questions.
It's $6,500, so it's not free dollar.
No further questions.
Cross-examination.
Good afternoon.
Good afternoon. It is.
It is indeed. So we're talking about February the 25th, and I believe you said the last time you were there was sometime the day before on the 24th. Is that correct? Do you recall what particular time that would have been? Is there a certain time that you're normally there?
Yes and no. I stopped by early morning. I have several projects going on, and I call it reviewing the troops. I go from one to the other, and the order in which they are is what it's needs must basis. So I just went in to check primarily to make sure that the heat was still working, because we had to jump a wire to keep the furnace running after our last break-in. I was only there for about 10 15.
And the last break-in that you were talking about, that was approximately a couple weeks before this?
Yes,
This microwave that you were talking about, is this like a over the range
Yes, it
model
is.
or? Okay. And this particular place, does it have any kind of security alarms, security systems, cameras, anything like that that you're aware of?
as now.
But at the time on February the 25th, did it or did it not, or
It
do you
did
know?
not. In 44 years in this business, I've been lucky. This is the first time I've ever really felt that I should have been doing that this last 44 years.
If I may, Your Honor. Thank you, sir.
Mr. Byrd,
I have no question.
can you redirect this witness?
No, Your Honor.
Okay, thank you, Mr. McGee. There is a sequestration order, so you're not to discuss any portion of your testimony with any other witnesses, okay?
Understood, yeah.
You're free to go. Are there any additional witnesses?
No, Your Honor.
Is the defense calling any witnesses?
We'll be relying on the evidence presented, Your Honor. Thank you.
You can make your argument.
Your probable cause has been met here. I asked you by the case of as charged in the complaint. I don't have it written in my laptop, but I believe it's a jury instruction 31.2 I was relying on, I think. So common sense goes a long way, Your Honor. I ask that you bind this case over as charged.
Not 31.2. Jury instruction what?
I don't
think
have
that's
it.
arson.
Let me see if my laptop will open.
Oh, this is home invasion second degree, correct?
25.2B.
Okay, got it. Defense.
Thank you, Your Honor. I'm going to oppose the people's motion for bind over and ask that the matter be dismissed. I understand the burden is probable cause, which is a low burden, but nonetheless, it's a burden that the people must meet. I think we have some circumstantial evidence here, but I think at best, it may put Mr. Dwayne McGinnis within some property that may have been stolen or removed from the house. We don't have any direct or I believe circumstantial evidence otherwise indicating that Mr. Dwayne McGinnis entered that house or broke and entered that house or took or stole any property from that particular house. So I think at best, they have a circumstantial case that falls on a probable cause determination because I do not believe people have met their burden. Thank you.
Thank you, Your Honor. I would concur with Mr. Austin. I would simply also add that I actually heard zero testimony that this was a dwelling.
Any re-argument?
I may reopen the proofs if if Your Honor believes this is not a dwelling.
I don't know what it is. Like, this can't be my belief is. I don't know anything about 2107 Real Road other than that on February 25th, officers were dispatched there for breaking and entering. And then we have Mr. McGee, who said he's a builder for 2107, and he was commissioned by the land bank. He probably could have provided a little bit more, so I'll allow you to reopen the proofs. I don't know if you can grab them still.
But yeah, well, I can see what was out there. I can bring anybody. Let me, can I step up for a moment?
Yes. Last name McGee, tell them don't let them leave. They always act like they don't know who's downstairs. They always act like they don't know who's downstairs. Yeah, they always act like they don't know who's downstairs. If he left here, he's gonna go through there. He's got to. Yeah.
Is this?
Can you swear you back in? You still solemnly swear to tell the truth, the whole truth under penalty of perjury.
I still do.
Thank you.
The address we just talked about earlier, what is that address?
It is a 3-bedroom, 2-bathroom home
It's a dwelling.
as well.
No further questions.
The cross-examination.
I have none, Your Honor.
None, Your Honor.
Thank you. Thank you, Mr. McGee.
Maybe I should leave my phone.
Let me give you my card, just in case. Have you ever called you before?
I don't remember.
Now I know.
Okay, no, I don't think there's any further argument, correct?
No.
Okay,
There's not any further argument, Your Honor. I just wanted to just make a record. I understand the court's ruling as it relates to reopening proofs, but just to preserve the issue, I would have objected to that. People had the opportunity during their case in chief. There was a deficiency in that, and so I just wanted to object.
thank you. Thank you. Okay, and so we have here count 1 in both files, home invasion in the 2nd degree. We've got the elements in the previous file, and those elements apply here as well. First, that the defendant broke into a dwelling, and it doesn't matter whether anything was actually broken. However, some force must have been used, opening a door, raising a window, and taking off a screen are all examples of enough force to count as a dwelling. Second, that the defendant entered the dwelling. It doesn't matter whether the defendant got his entire body. If the defendant put any part of the body into the dwelling after breaking, that is enough to count as an entry. Third, that when the defendant broke and entered the dwelling, he intended to commit, in this, I would assume it must be a larceny of some sort due to the nature, or the testimony about a microwave, and that the defendant was entered in, or was leaving the dwelling, he committed said larceny. And so we had testimony today, first from Officer Freeman. She testified that on February 25th, 2025, she was dispatched to the area at or near Rio and Stark. Her recollection was refreshed to the address of 2107 Rio Road. That's in the city of Lansing, Ingham County, state of Michigan. So that makes venue in this court appropriate. She stated that as she approached Rio Road, she observed two white males that she identified in the court today as the defendants by name, and that they fit the description that was given through dispatch of the suspects. Again, this dispatch of a breaking and entering. She stated Dwayne had a very large box and Alan was standing to the right with a blue dolly, and Dwayne loading the box on the dolly. Once she began to turn, she activated the lights, and she said she didn't activate her lights prior to because they had not, the suspects had not noticed her, and I'm assuming she wanted to see how much she could visualize before they noticed her. Once the suspects did notice her, she said that they took off running. They were later apprehended. She Mirandized at least Alan, who stated that he had swallowed some heroin, so he had to be treated for medical. The officers recovered a microwave. Officer Adam Walter indicated that he located a fully boxed microwave next to the dolly. We had testimony from the builder, Mr. Wayne McGee, testified that he again was commissioned by the Lansing, the land bank, to build this property, and that he had been there prior to, or the day prior to, and that there was a brand new microwave that was inside of the unit for the purposes of being installed. The court did reopen the proof to address specifically whether or not this was a dwelling. There was no testimony at the case in chief about it being dwelling, but there was sufficient enough testimony based on other elements that the court could reasonably understand that this must have been a dwelling, and that could have continued. Land Commission doesn't commission people to build anything but dwellings. And so with that being said, the court is satisfied based on the testimony evidence that there's more than mere suspicion that the action of a home invasion took place. There was a report of a break and entering by some witness who didn't obviously appear today, but that was what caused the officer to appear. And the officer saw the individuals outside of this resident loading at least a brand new boxed microwave, which the builder said was inside of the unit to be installed. They were loading this, and then when they saw the officer, they took off running. The court will bind this matter over for a bind over date of March 26th. The next court date that these defendants will need to appear in will be a pre-trial, and that date will be set after the court receives this file.
Thank you, Your Honor.
I've not gone off the record yet.
Oh, I did get that.
For Alan McGinnis Jr., file number ending in 621, there's a bond of $8,000 cash surety, and that will continue. On the other file, the bond was set also at $8,000 cash surety. And says no contact with Brigida Dewar, not to be within 2,000 feet of wherever she is. Then the other file, there's a no contact with Wayne McGee, not to be within the 2,000 feet of wherever this person lives or is employed. That will continue for Dwayne McGinnis, file number ending in 232. The bond is set at 8,000 cash surety. There's a no contact order for Brigida Dewar as well. And then in file number ending in 622, 10,000 cash surety. That will continue. And a no contact order with Dennis Van Cleve and Wayne McGee, not to be in contact or within 2,000 feet of wherever they are. That will also continue. Any additional matters for the record?
No, Your Honor, thank you.
I have nothing additional to add from Mr. Dwayne McGinnis, Your Honor. Thank you.
You're all set. Told them to bring it, you have someone that needs to be sent it?
I am sensing Ashley Allen. She should be downstairs.
Sweet already, I'm someone already.
Ashley Allen, she's the first one. No, the other. She was on probation for those days.
Do I need to pay for sentencings here? That would be fair.
Thank you.
That's great.
We need to let her know to bring Ashley out up because she didn't ask me. So I'm sure she doesn't.
I'll just go sit down. I probably can catch up. to her.
Or just get one of the security officers to radio her.
Okay.
Wait out, what?
The address and so.
I don't care. You guys know who I am, don't you?
Thank you.
Thank you so much. You have a good day.
All right, thank you.
George. You think he did better? I haven't seen him forever, but he did. Just one more screen. And then I'll get this done and go over to Judge Jim and start the afternoon. You want to second?
No, you. The record in the matter of the people of the state of Michigan versus Ashley Allen, and this is 24-01847. Appearance, please.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Ashley Allen, who is to my right.
It was a date scheduled for sentencing. I do have a pre-sentence report. Counsel, it was prepared on the 10th of March. You got a copy of this?
Yes, I did.
Okay, any reason to make corrections, updates, or deletion?
No, Your Honor.
Make allocation.
Thank you, Your Honor. In regards to the recommendations from the probation department, certainly Ms. Allen does want to pay back the $1,500 that she'll owe to JSG. We have no dispute that that is the amount that they pay to replace the tethers that are beyond repair. She does, as reported in the PSI, to receive a Social Security payment, so I believe that she'll be able to make payments on that. Her hope is that she can pay it off in the time that well, right now the recommendation is 12 months non-reporting. She would hope that she can pay it off in that time, but I've explained to her that the hope is that, you know, she can make those payments and stay out of trouble, so that she can complete probation. But obviously that'll be up to the court. She is scheduled for release on April 1st. So technically she doesn't get any credit for any of the time that she's been in jail since January 3rd. But if the court would want to consider giving her some credit, she has 19 days from today until she's released on April 1st. So we have no objections to being put on probation. We both think that she would be a good candidate for probation, or at least for a term of probation, to hopefully make sure that she stays out of trouble. Besides that, Your Honor, want the court to know, because it's not in the PSI, that while she's been in custody, she has been able to complete the parenting class. And before she's going to be released on April 1st, she will have MRT completed, and she is currently enrolled in CATS and will have that to enroll in after she's released. She will go to CMH and get counseling set up. It's substance abuse as well, right? Yeah, there's substance abuse. And so I think that's why there is a recommendation that the court order her to continue her current mental health counseling. So that's something that she also plans to do. Thank you.
Thank you. Does your client want to make a statement?
No, ma'am.
Yeah, I think the recommendation is appropriate. It's not requesting an intensive oversight on your part, just a non-reporting probation that will give you an opportunity to show that you're going to be compliant with the payment plan and not engage in any further violations or pick up any new cases during that time frame, and that you'll get the help or continue to get the mental health counseling that you need, which you're already engaging in at this time. So I'll adopt that recommendation. It's going to be 12 months non-reporting probation, and you'll continue your mental health counseling. And pay restitution. It says that the amount for restitution in this is $1,500, I believe. Go to JSG monitoring. get a restitution form. There's a $75 crime victim rights fee that will be assessed and a $50 state minimum cost that will be assessed. Outweigh discretionary fines and costs, and oversight fees will be waived. While out on probation, you're not to engage in any assaultive or threatening behavior. You're not to use or possess alcohol or drugs without a valid prescription.
Yes, ma'am.
And you're not to possess a firearm, ammunition, or weapon of any kind, okay?
Yes, ma'am.
Okay, let's see. So your payments will be about $135 a month. Monthly for restitution, okay?
Yes, ma'am. Your Honor, it's a good question. Your Honor, when would you expect her, for the first payment to start being made?
Well, she technically won't initiate or begin her probation until after she's out.
So
after she's
April
released.
1st, so
You'll get out and
where would I
you'll
make
you'll
the
have to,
payments to?
you'll be making the pay, you can make them at the court because they gotta be paid to JSG, so you'll come and make them here, okay?
Yes, ma'am.
Okay, do you have any other questions?
No, ma'am.
Let me make sure we have a valid address for you post your release. You gave an address for your aunt, I believe?
3961 West 8th Street,
Correct.
Fremont, Michigan, 49412.
That's the address we have, and a phone number ending in 6827.
Yes, ma'am.
Okay, that's the contact information that we have for you.
894-6826, yes. That's the
So
number.
it should be 6826.
Yes, ma'am. My name's Denise Bennett.
Okay, sounds good. Okay. Any additional matters for today's record?
No, Your Honor, thank you.
You're all set.
Thank you, ma'am.
You're welcome. Mr. Freeman. Come on. On the record in the matter of the people of this state of Michigan versus Richard Greenman, actually City of Lansing versus Richard Greenman. This is file number 20-01645, council appearance.
Thank you, Your Honor. Good afternoon. Jared Austin appearing today on behalf of Mr. Greenman for the purpose of his arraignment only.
Okay, and Mr. Greenman, this was in warrant status because you failed to appear for a violation arraignment. I do have a request in summons for probation violation. The allegations are that you violated the amended order of probation from September 20th, 2024 by failing to stay engaged in intensive outpatient. And per MMRS, you failed to attend sessions on December 6th, December 9th, December 13th, December 16th, December 20th, 27th, 2024, and then also January 2nd, 3rd, 6th, 13th, and 15th, 2025. I also have another request and summons for probation violation alleging that you failed to submit to testing for AberHealth and failed to test on December 21st, 26th, 29th, and January 6th. So you have the right to have a contested hearing on these violations. You have the right to be represented by an attorney at these hearings. If you're found to be in violation of your probation status, your probation can be revoked. You can be sentenced to just serve straight jail time. Do you understand that?
Yes, sure.
Okay, did you request an attorney to represent you for the hearing?
Yes, he's making application, Your Honor, yes.
The court will enter a plea of not guilty on your behalf. We'll set this for hearing.
March 25th at 1:15.
March 25th at 1:15. have any questions at this time?
No, Your Honor, I'm scheduled to go to Rise, 3/4 housing today. So will this make it so I'm not an active warrant, so that I can?
Your schedule will arise today.
Yes,
You'll be there still March 20.
yes, ma'am. And I'll be in there for at least 90 days.
I'll note that here in the file. And has your phone number changed at all?
No, ma'am, 619-4314.
Okay, sounds good. Any additional matters for the record?
No, Your Honor, the court set an official bond for Mr. Agreement on this particular violation.
No, we don't typically, she's gonna continue his probation
Okay, thank you.
at this time, quash the warrant.
All right, thank you, Judge.
You're welcome.